Hello, everybody. Welcome again to Frequently Asked Questions Friday. Today we have Mr. Scott Staha. Scott is the lawyer that's been with me the longest. You've been with me how long, Scott?
22 years.
22 years. Scott, why don't you tell everybody a little something about yourself?
I've been here 22 years. I practiced in the litigation department, handling personal injury claims, trucking claims, wrongful death claims. I was born and raised here in South Texas and have practiced pretty much all over the state.
Where were you born?
Victoria, just up the road.
And you got brothers and sisters?
Two sisters.
Two sisters, okay.
Both still live in Victoria along with mom.
Okay. And I'm married?
Yes, I have. Been married almost 25 years to a lawyer, another lawyer.
Oh, that's scary. All right. Well, and no kids, right?
No kids, 3 dogs.
At least no kids that you know of.
3 dogs.
All right. Anything else you want to tell us about yourself? What a wonderful guy you are. What's your favorite drink?
Can I say that? No.
It's not TV.
It's not TV.
It's
My favorite drink is a Grey Goose martini, straight up dry with 2 olives.
All right. And your favorite cut of steak?
Ribeye.
Ribeye. All right. Anything else you want us to know about you before we get started here?
Not that I'm willing to reveal on Facebook Live.
All right. So Scott's topic is the question, do I still have a claim if my medical bills were paid by insurance? So basically they're saying, hey, I got injured, but hey, all my bills got paid. So, I guess I don't have a claim, do I?
Actually, you do. You have a claim in the sense that along with any personal injury claim, there are different elements to your claim. In a typical, for example, in a car wreck case, you could have, for example, your medical bills, both past and future. You could have physical pain and suffering, both past and future. Physical impairment, both past and future. If you had any type of cuts on you that resulted in scarring, you would have a disfigurement claim. In addition, you would still have a property damage claim if you were the owner of the automobile, or if you had personal items inside the vehicle that were damaged as a result of the wreck. You would have a claim for those items of personal property that were damaged. So just because your medical bills may have been paid by insurance certainly does not prevent you from asserting a claim for the many other elements that you have. In addition, although the medical may have been paid, you can still make a claim for the medical that was paid by your insurance, because most insurance policies have what's called a subrogation clause in them, simply meaning that if you are injured and they have paid your medical bills as a result of those injuries, they're entitled to be repaid for those medical bills that they paid. And so, although you won't be repaying the full amount of the medical bills, you'll be paying back the subrogated amount. So yes, you still have a claim, and just don't think that if the bills were paid that your claim is done and over with. You should certainly consult with an attorney to advise you. You should consult with Herrman Herrman to advise you on other aspects of your claim.
Okay, so I think you mentioned disfigurement, past and future, mental anguish, past and future, pain and suffering, mental anguish, pain and suffering, past and future, and property damage. I don't think you mentioned lost wages or wage earning capacity.
Correct. I left that out. That is another element. If you were unable to go to work, and as a result of that you lost out on income, or if you were injured and you cannot return back to work at all in the foreseeable future, you would have a claim for loss of earning capacity. which simply means that the money that you could have earned, that you had the ability to earn in the future, you can seek compensation for that also.
All right, and is there something called loss of consortium?
Yeah, there is. For example, if you are married, you have your spouse would have a loss of consortium claim, and what that is, it's a claim associated with the benefits associated with being married, the enjoyment of y'all going out and doing things together, the enjoyment of being husband and wife. That would potentially also be a claim that you would have.
What if you don't enjoy being husband and wife? You don't enjoy doing stuff with you?
Then there's probably not much of a claim there for loss of consortium.
What about kids? Would kids have a loss of consortium claim?
I think only in the context of if there was a death, there would be a loss of support, a loss of enjoyment associated with if there was a resulting death.
And then you'd also have loss of inheritance, I guess, too.
Correct. In other words, that which you would have inherited from your parent in the future, provided that your parents would have left you in your will, you would be able to assert that kind of claim also.
All right. Let's go back to this subrogated interest you were talking about before, because that was a little bit confusing. Can you give us an example? Like, let's say you have $100,000 in medical bills, and insurance company pays. Well, what do insurance companies typically pay? Let's say Blue Cross Blue Shield, Humana, United Healthcare. Like, what percent would they usually pay on, say, $100,000 in medical?
Normally they have a contracted rate. That contracted rate is usually almost pennies on the dollar. Typically on a $100,000 bill, you could expect to see a subrogation interest of somewhere between maybe $20,000 to $25,000 that would have to be repaid. So definitely substantially less than the original bill was.
So, so let's go through that again. So you got $100,000 in bills. The insurance would pay how much? About how much?
About $20,000 to $25,000.
And then would you have to pay them back that entire $20,000 to $25,000?
No, you actually can negotiate with them in many cases. They will accept a reduction because what they're doing is the insurance carrier is receiving a benefit because of you, because you went out, retained an attorney to pursue this claim. They don't get a free ride, so to speak. They have to pay their fair share. And in many cases, we can reduce that subrogation interest. On average, probably a third of that, in some cases, 50%. And depending on the facts, we have once in a while been successful in getting a waiver of the subrogation interest.
And what does that mean, waiver of a subrogation?
Basically, they agree to waive their subrogation. In other words, they agree not that they will not accept any money. They won't demand any money for that subrogation interest, which means you owe them nothing.
So it's like a windfall to you.
It's a windfall to you.
Right. So just that alone might be a good reason to hire a lawyer.
Absolutely, absolutely. You should always consider hiring or consulting with and hiring an attorney. The insurance companies that are out there are certainly not looking after your best interest. They are looking after their own interest in their own pocketbook, and their goal is to basically get you to accept as little as possible, and or just outright deny your claim, figuring that if you do not have an attorney, you'll just go away So you should always consult with an attorney and get the best advice you can on how to preserve your claim, and also how to maximize what you're entitled to for your injuries and damages.
And lastly, let me just let's talk a little bit about hospital liens. How exactly do those work, and is there any way around them, or any way to get around not paying the hospital back?
Well, if the hospital hasn't actually gone out and filed a lien, they have a much more difficult time of being able to assert an interest in your settlement proceeds.
And just, for people who don't know, I mean, what does that mean? They go file a lien. I mean, most people have no idea what that means. I mean, they think, oh, well, I guess my house has a lien. The bank's got a lien on my house, or the IRS, I didn't pay my taxes. The IRS put a lien on my stuff, my bank account. But what is a hospital lien? What gives them the right to file these things against you?
It's not much different than, for example, a tax lien or a mortgage. What it does is it is under the property code, Texas property code. There's a provision that allows a hospital to go out and to file a document down at the county courthouse, and this document basically says, we provided services to this individual as a result of a car wreck or other personal injury. And what it says is, if you collect any monies, we are entitled to be repaid for those services that we provided to you. There are some strict requirements that a hospital must comply with in filing these liens. In certain cases, if they don't, for example, if the individual does not seek services within 72 hours, or basically 3 days, but say 4 days later goes to the hospital, hospital is not permitted to file a hospital lien because the services must be within the first 72 hours. Also, the services, for example, if it's a very severe injury that requires hospitalization over a long period of time, anything over 100 days would no longer be permitted under a hospital lien. It's only the first 100 days. They also have to file it in the county in which the services were rendered. If they file it in a different county, it's not a valid lien. And if they attempt to file a lien against, for example, what we call uninsured motorists or underinsured motorist coverage, which is your own personal coverage, a hospital lien does not attach to those proceeds. It only attaches to proceeds from a liability policy belonging to the responsible third party that caused your injuries. There are a number of ways to attack a lien. First and foremost, there are, again, some technical requirements, but one of them is the bill must be reasonable. The charges must be reasonable. If they are not, that is a basis to attack the hospital lien. It requires a little bit more effort because you do have to go down and file an action in order to determine what the reasonable amount of the bill is. In many cases, we have been fairly successful in negotiating down the hospital liens, on average 50% on average, sometimes even a little bit more than that.
Okay. Now, what if the hospital forgets to file the lien, or they file in the wrong county, or they have some, they don't meet one of your other tests?
Well, they don't have a lien. In other words, they can't hold up your settlement money. Doesn't mean you don't owe the bill, but it won't hold up your settlement. You won't have to specifically withhold a portion of the settlement funds to pay that bill. But once again, doesn't mean you don't have to pay them. They just can't be entitled to the first share of monies from the settlement.
So it's gonna be a whole lot easier to negotiate with them if they don't have a lien or they misfiled the lien.
Absolutely.
Than if they do.
Absolutely.
So, and you know, what we do a lot of times is we give the money to the client and say, look, if you want us to negotiate with the hospital for you, since they don't have a valid lien, we'll do it. But we need to give you the money first so before they go file one. And
Right.
And now we can just say, hey, you know, we'll pay you $5 a month for the next, 20 years. And they don't want to do that. So they'll agree to a hugely discounted amount just so they can get something.
Absolutely. Anytime you have, anytime the hospital has knowledge that there's an attorney involved, their whole mindset changes about how much money they're going to be able to get from the patient that they treated. We have found that many times that that clients can get a much better deal from a hospital when, for example, they don't realize that there's been an attorney involved until much later down the road. They can usually cut a pretty good deal. Hospitals are willing to work with patients unless they realize that there's a lawyer involved, and then they want to play hardball and try to extract as much as they can out of the settlement to pay the bill.
But that's where the lawyer comes in to
Correct.
play hardball with the hospital. All right. Well, anything else you want to add on the subject?
Other than if you've been involved in a car wreck, serious injury, please come see us. We can certainly help you.
All right. All right. Well, we're out of time here, but let me just mention a couple things. So the scholarship entry deadline was December 1st. It's over. We are picking winners right now. We are down to the top 10. And I can tell you that there are some Texas people in the top 10. So stay tuned. Next Friday, December 21st, we are going to announce the winners of the scholarship prizes. First place is $2,500. Second place is $1,500. Third place is $1,000. And we're going to start the scholarship again in January and for next year. So if you didn't get in this year, make sure you get in next year. But stay tuned. 1 week from today, we'll make the announcements. Also stay tuned because we are going to have a contest to get people to register to vote. We had a pretty good 2018 where we got a lot of new people registered to vote, and then a lot of them that registered didn't go vote. But we're hoping to get more people registered to vote and get them to turn out for the 2020 elections and any special elections in between. So it's really, really important, we think, for democracy, for people to be registered to vote. So we're going to come up with a contest and probably give away monthly drawings for everybody that registers to vote. So, because we don't want you guys waiting until the last second to register to vote and then you forget, or, it's raining outside or whatever. So anyway, stay tuned for that. We'll make that announcement hopefully next week also. So until next time, we will see you guys next Friday, same time, same channel. And Scott, thanks for joining us here.
You're welcome. Enjoy it.
All right, man.
Be happy to come back anytime.
All right, we'll have you back.